The rules are suspended. We will now move to second reading. The clerk will read.
Assembly Bill 3 and 4.
The first extraordinary session is recessed under the call of the Speaker. We'll now move to convening the second extraordinary session. Without objection, we'll substitute the prayer, the pledge, and other opening procedures in the regular session for those items in the second extraordinary session. Ms. Garcia, you're recognized for your motion.
Mr. Speaker, I request unanimous consent to suspend Assembly Rule 63 and allow AB 1 and AB 2 to be taken up today without reference to file for purpose of second reading.
Ms. Waldron objects to unanimous consent with regards to the suspension of these rules. At this time, Ms. Garcia is moving that we suspend the rules to allow these two items to be taken up today without reference to file for purpose of second reading. That has been seconded by Mr. Holden, objected to by Ms. Waldron. We will take a roll call vote on this motion. The clerk will read. The clerk will open the roll. All members vote who desire to vote. This is a procedural motion. It takes 41 votes. Ms. Garcia is asking for an aye vote. Ms. Waldron is asking for no vote. All members vote who desire to vote. All members vote who desire to vote. Okay. The clerk will close the roll, tally the votes. Ayes 45, noes 26. The motion passes. The rules are suspended. Now going to second reading. The clerk will read.
Assembly Bill 10, 6 with amendments, 9 with amendments, 1 and 2.
The second extraordinary session is recessed under the call of the Speaker. We are now back in regular session. Business on the daily file. Second reading. The clerk will read.
Senate Bill 134, 145, 255, 304, 308, 475, 731, 792, 321, 734, 800, 803, 148 with amendments, and 478 with amendments.
All bills will be deemed read and amendments deemed adopted. We're now going to go to concurrence in Senate amendments, starting with file item 15, which we will pass and retain, going to file item 16, AB 556. The clerk will read.
Assembly Bill 556 by Assemblymember Irwin, and act relating to charitable trusts.
Ms. Irwin, you're recognized.
Thank you, Mr. Speaker and members. AB 556 improves disclosure requirements for for-profit charitable fundraisers, for nonprofit charitable fundraisers, and clarifies the Attorney General's 10-year statute of limitations includes for-profit fundraising firms and other third parties who engage in misconduct relating to charities. Senate amendments expand the definition of commercial fundraisers for charitable purposes to include fundraisers that participate in specified actions and types of fee arrangements that warrant additional disclosure to donors. AB 556 has received 0 no votes in both houses and has no opposition. I respectfully ask for your aye vote.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the votes. Ayes 68, no 0. The Senate amendments are concurred in. File items 17 and 18 will pass and retain. File item 19, AB 147. The clerk will read.
Assembly Bill 147 by Assemblymember DeBobne and others, and act relating to post-secondary education.
Mr. DeBobne, you're recognized.
Good morning, Mr. Speaker. Members, AB 147 is back for concurrence. Minor amendments were taken in the Senate Education Committee, which clarified that it's role of the institution to determine if the animal is appropriate for adoption. Additionally, amendments were narrowed for the definition of animal adoption organizations. I respectfully ask for your aye vote.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the votes. Ayes 69, noes 1. The Senate amendments are concurred in. File item 20 will pass and retain. File item 21, AB 557. The clerk will read.
Assembly Bill 557 by Assemblymember Irwin, and act relating to nonprofit corporations.
Ms. Irwin, you're recognized.
Thank you, Mr. Speaker and members. AB 557 will create a streamlined administrative dissolution process for inactive nonprofit corporations that have been suspended for at least 48 continuous months after proper notice has been served. The Senate amendments increase communication between the departments involved by requiring the Attorney General to be notified when a nonprofit is administratively dissolved. I respectfully ask for your aye vote.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the votes. Ayes 69, noes 0. The Senate amendments are concurred in. File item 22, AB 780. The clerk will read.
Assembly Bill 780 by Assemblymember Williams and others, enacting the alcoholic beverages.
Assemblymember Williams, you're recognized.
Members, AB 780 will update the Tide House restrictions to allow small distillers to use Twitter, Facebook, and other forms of social media to post about alcohol product availability without a direct inquiry on social media. Additionally, 780 will expand the listing of off-sale retailers to include on-sale and off-sale retailers, creating more consistency between federal and state regulations. Additionally, there's some Senate amendments that are code cleanup. I ask for your aye vote on Senate amendments.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the votes. Ayes 72, noes 0. The Senate amendments are concurred in. File item 23, I understand we will pass and retain. File item 24, ACR 12. The clerk will read.
Assembly Concurrent Resolution 12 by Assemblymember O'Donnell relative to Officer Robert Joe Mata and Officer Roberto C. Sanchez Memorial Highway.
Mr. O'Donnell, you're recognized.
Thank you, Mr. Speaker and members. ACR 12 seeks to honor the life and public service of police officers Robert Joe Mata and Robert C. Santiago, who tragically lost their lives in the line of duty. The resolution designates a portion of State Highway Route 110 in Los Angeles as the Officer Robert Joe Mata and Officer Robert C. Sanchez Memorial Highway. ACR 12 recognizes the contribution these two men have made to their community as well as the ultimate sacrifice. I respectfully ask for an aye vote.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the votes. Ayes 71, noes 0. The Senate amendments are concurred in. Moving now to file item 25, AB 57. The clerk will read.
Assembly Bill 57 by Assemblymember Quirk, enacting the telecommunications.
Mr. Quirk, you're recognized.
Good morning, Speaker and members. This bill makes it easier to improve telecommunications infrastructure by enforcing the existing FCC timeline for a local jurisdiction to act on a permit for a wireless telecommunications facility. Senate amendments clarify that the bill upholds the authority of a city or county over decisions regarding the placement, construction, and modification of a wireless telecommunications facility. This is a modest step to ensure that California has the necessary infrastructure to provide services to its citizens and to compete on a national and global scale. I respectfully ask for your aye vote.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the votes. Ayes 60, noes 6. The Senate amendments are concurred in. We're going to pass and retain file items 26 and 27. File item 28, AB 248. The clerk will read.
Assembly Bill 248 by Assemblymember Roger Hernandez and others, enacting to healthcare coverage.
Mr. Hernandez, you may open.
Mr. Speaker, members, AB 248 is back from the Senate for concurrence. AB 248 protects workers by closing federal loophole that allows large employers to meet lower standards for health coverage than small employers or individuals. Amendments taken in the Senate exempt federal grandfathered health care policies. The amendments were written in consultation with the Department of Managed Health Care Services. This bill has enjoyed bipartisan support throughout the process, has minimal fiscal costs, and was sponsored by Health Access California. Not as small as yours. I respectfully ask for your aye vote.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the votes. Ayes 46, noes 23. The Senate amendments are concurred in. File item 29, AB 306. The clerk will read.
Assembly Bill 306 by Assemblymember Hadley and others, enact relating to school districts.
Mr. Hadley, you're recognized.
Thank you, Mr. Speaker. I rise today to concur in Senate amendments for AB 306. AB 306 will allow the child of an active duty military parent to apply for a public school district transfer and prohibits the school district of residence from denying that transfer as long as it is approved by the transferring school district. Senate amendments streamline the bill and avoid any unnecessary confusion for school districts. I respectfully ask for your aye vote.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the votes. Ayes 70, no 0. The Senate amendments are concurred in. Moving now to file item 30, AB 349. The clerk will read.
Assembly Bill 349 by Assemblymember Gonzalez and others, enacting in common interest developments, declaring the urgency thereof to take effect immediately.
Ms. Gonzalez, you may open.
Thank you, Mr. Speaker. Members, AB 349 is back for concurrence. The amendments taken in the Senate add a co-author and make some clarifying minor technical modifications. The bill has received bipartisan unanimous support, and I respectfully ask for an aye vote.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the votes. Ayes 66. Noes 1. The Senate amendments are concurred in. Going now to file item 31, AB 422. The clerk will read.
Assembly Bill 422 by Assemblymember McCarty, enact relating to transit.
Mr. McCarty, you may open.
Thank you. AB 422 is back for concurrence. This bill grants our local transit district, Sacramento RT, with the opportunity for short-term borrowing. Senate amendments require the SAC RT to immediately repay loans upon federal funding receipt. There is no opposition to the bill. Respectfully request an aye vote for concurrence on Senate amendments.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tally the votes. Ayes 49, nays 15. The Senate amendments are concurred in. File item 32, AB 465. The clerk will read.
Assembly Bill 465 by Assemblymember Roger Hernandez, enact relating to employment.
Mr. Hernandez, you are recognized. Mr. Hernandez.
Mr. Speaker and members, Assembly Bill 465 is back on concurrence and Senate amendments. Again, this bill will ensure that waivers of important employment rights and procedures arising under California law are made voluntarily and with the consent of the employee and not made at the condition of employment. The Senate amendments respond to opposition arguments and narrow the bill as follows. The Senate amendments eliminate the $10,000 civil penalty. The Senate amendments exempt certain registered employees in the securities industry regulated by the Financial Industry Regulation Authority, also known as FINRA, and covered by their dispute resolution process. The Senate amendments exempt employees represented by legal counsel in negotiating the terms of these agreements. Again, the Senate amendments make this a narrower version of the bill that was passed off this floor on May 14th. At the end of the day, no worker should be forced to choose between a job and giving up core labor rights and protections. I ask for your aye vote and concurrence with Senate amendments.
Mr. Wagner, you're recognized.
Thank you, Mr. Speaker, and I do rise in opposition. With a sincere thanks, over in the Senate, they did make the bill a little bit better, but there are several points that need to be made because, like we have on prior bills, we are acting in opposition to federal law, and we're acting in opposition to existing state law. First of all, there's a very real, not just possibility, but probability that this bill will be preempted by federal law. Thank you, Mr. Speaker. The United States Supreme Court has spoken a couple of years ago in the Concepcion versus AT&T case. A state cannot enact a statute that interferes with arbitration, and the California and U.S. Supreme Courts have repeatedly upheld mandatory employment arbitration agreements. We are acting against the considered wisdom of those cases. In addition, it is theoretically a defect in the procedure that, well, the employers always get to pick the arbitrators. In fact, that is also not true in the Sanchez versus Western Plaza Enterprises, Inc. case, a case out of our California appellate courts. The employer arbitration agreement, where the employer designated the specific arbitrator, did not satisfy the neutral arbitrator requirements that exist in the federal law and the state law that I mentioned before. And so it is simply wrong to say that that this bill is needed because the employers get to pick the arbitrator. Not true. And it is also not true that what we hear from the proponents, that arbitration agreements force the waiver of substantive rights. A case going back over 20 years, the Armin Direz versus Foundation Health Care case actually goes back 15 years, has been the law for the last 15 years, and specifically holds that what the proponents say about waiver of substantive rights is simply not true. This bill isn't necessary. This bill conflicts with federal law. This bill is preempted by federal law, and both our state courts, which are much more generous towards employees than even the federal courts usually are, our state courts say this is an accepted, in fact, a preferred procedure. You can find, if you do a little bit of Googling, the former president of the ACLU, Louis Maltby, saying, in fact, that arbitration is really the only true form of justice available to most low-wage workers, because, quite frankly, they can't afford the fees that this body will be forcing them to incur going into a civil trial. So the bottom line is bad law, unnecessary law, law that conflicts with considered California decisions and hurts the very people it's supposed to try to help. I urge a no vote.
Ms. Grove, you're recognized.
Thank you, Mr. Speaker. I, too, rise in opposition. When this bill first came to the floor, the author argued that employees do better in litigation than in arbitration. And in the real world, I can tell you that is entirely not true. Louis Maltby, as my colleague just said from Orange County, did say that that arbitration is the only forum, or one of the only forums, that provides true justice to low-income wage workers. Louis Maltby is not somebody that I politically would agree with on almost any issue, except particularly this one. He is an ACLU attorney, and he also is the president of National Work Rights Institute. He also said that if a post-offense was happened, that less than 6% of the agreements for arbitration would even take place. So that leaves 94% of our employees that are low-income wage workers out in the cold seeking legal counsel. Now, there are legal counsel out there that will represent these employees on a pro bono basis with a percentage based on the settlement that they acquire from the employer. When you think about that, and you look at the reviewed cases that I've looked at over the last 2 years because of another issue we have with the Private Attorney General Act, these cases, when you review these cases of settlement, the employer pays out hundreds of thousands of dollars, almost millions in some cases. One case I reviewed had $6 million in settlements. The attorneys retained almost 75% of that settlement. Then the next group that got the money was the admin company that did all the administration, filed the checks, got the information, gathered it based on wage and hours that were reported, and then they did their formula and calculation to determine what employees would get what award. And then the next section was the fee section. Then the little section that was left at the bottom was divided up between the 100 or 200 or 300 employees left at the end. So if you take that small section, some of these employees were getting 16 cents. Some of them got $1.65 per check. But that did add up to a sum of money if you take 1,000 employees in account. But the bottom line is that arbitration creates a faster mechanism for a grievance for an employee to be able to get their wages if there is a dispute. I find myself as one of the most conservative members on this floor aligning myself with an ACLU attorney that agrees with me on this issue, or I agree with him because he's older and he said it first. So I would ask that because of this issue and because of the court system that it would tie up, the only winners in this are the lawyers that I applaud the author on another bill that we're working on, that we're trying to stop these lawyers from gaming this system. This bill only rewards those lawyers who choose to game this system and take. And the only person, or the two people that it hurts, are the employer and the employee. And we need employers to create jobs, and we need employees to work those jobs, be gainfully employed so that we have economic security here in this state. And for those reasons, and being an employer in the private industry and understanding how this law will affect all employees that are employed, I urge a no vote.
Mr. Harper, you're recognized.
Thank you very much, Mr. Speaker. This bill will clog our court system further than it already is, and it doesn't give any additional resources to be able to alleviate that, being incredibly short-sighted. Makes California a riskier place to do business, clearly hurting our business within the state of California. And for that, I ask for a no vote on this bill.
Dr. Weber, you're recognized.
Yes, Mr. Speaker and members, I rise in support of AB 465. This really is a bill about choice, and all the arguments we heard concerning this bill were the same arguments we heard concerning my bill on arbitration and choice, that it would be illegal, it would be this, it would be that, and none of that proved to be true. But it is about choice. That we're talking about forced arbitration and the choice of employers and employees to basically choose and not choose, and not to be forced to sign an arbitration agreement in order to get employment. That is extremely important. A lot of misinformation thrown on the floor about attorneys and fees. Even when you go to arbitration, you're probably going to get an attorney. I've been in arbitration, and I think it cost me as much in arbitration as it would have cost me to go to court. So all this stuff that's going to be this free, happy-go-lucky, kumbaya experience in arbitration is all wrong. People should not be forced to have to sign an arbitration agreement in order to get a job. If they want to, that's fine, but they should not be forced to do so. I once again ask for your support for AB 465 because it really gives people choice, and that's what this is about. Choice is whether or not you want to engage in arbitration or not. And I expect my colleagues who generally don't like big government, who don't like oversight, who don't like to be forced into doing things, to recognize the importance of having the choice to either engage in arbitration or not. I respectfully ask support for AB 465.
Seeing and hearing no further debate, Assemblymember Hernandez, you may close.
Thank you, Mr. Speaker. I'd like to, as I close, first thank everybody's input. I appreciate the dialogue, and I want to address some of the points that were arisen. AB 465 is not preempted by federal law. The federal preemption doctrine is premised on the notion that these agreements are voluntary and entered into the consent with the consent of the employee. All this bill does is ensure that these agreements are in fact just that, voluntary. An agreement that is made as a condition of employment by its very nature is not voluntary. Federal law simply does not preempt involuntary arbitration agreements. Case law does not adequately protect workers. The reality is, to that notion, the reality is that getting a contract struck down as unconscionable is very difficult. Most workers, especially low-wage workers, don't have the resources, as shared by my colleague from Irvine, to litigate these clauses. They'll just give up, and likely to give up their underlying claims as well. Arbitration, the argument and the notion that arbitration is not good or fair for workers, the opposition cites data from 03 and 04 for the proposition that individuals fare well in arbitration, but the use of arbitration agreements in employment has skyrocketed since that time. A more recent 2015 analysis of arbitration data shows that workers win less and win less often in arbitration. As a matter of fact, nearly 80% of the time, the employer is winning. That means that 20% of the time, the employee is winning. And that's only workers who choose to go through the arbitration process. The vast majority of workers simply drop their claims rather than go through the forced company arbitration, meaning they have no access to justice whatsoever. This bill is critical to restoring the balance of power and ensuring that workers are not giving up enforcement of core labor rights under the threat of compulsion. I respectfully ask for your vote.
The clerk will open the roll. All members vote who desire to vote. 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 Mr. Hernandez, what's your pleasure? Mr. Hernandez has asked. All members vote who desire to vote. 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 Mr. Hernandez, what's your pleasure? All members vote who desire to vote. Mr. Hernandez, what's your pleasure? Move the call? Okay. Mr. Hernandez moves the call. Colleagues, we're going to go back very briefly to one of our previously scheduled guest introductions. I'd like to recognize Mr. Gray at his desk. Where's Gray? Mr. Gray?
Thank you, Mr. Speaker, members. I rise today to recognize constituents from my hometown of Merced. We are joined today by Gary and Cheryl Eno, as well as their grandchildren. Gary and Cheryl both attended Merced High, as I did. Gary went on to be a mortgage originator and Cheryl a media tech at Merced College. Their grandson Quentin is a sophomore at El Capitan High School and granddaughter Marin in 8th grade at Rivera Middle School. Mr. Eno is the vice president of the Merced Breakfast Lions Club and the youth coordinator. Please join me in welcoming the Eno family to the California State Assembly.
And we're going to go back briefly to motions and resolutions. Ms. Garcia.
Mr. Speaker, I request unanimous consent to suspend Assembly Rule 63 to allow all bills heard today and reported from the Appropriations Committee today, August 27th, Monday, August 31st, or Tuesday, September 1st, with a recommendation of do pass as amended, do pass to consent, or do pass as amended to consent, and with unanimous support of at least 15 affirmative votes to be ordered to the second or third reading file or consent calendar one legislative day prior to the day required under the Assembly and Joint Rules.
Without objection, such shall be the order. Ms. Garcia.
On behalf of the author, I request unanimous consent to withdraw AB 1171 from the engrossing and enrolling and to be held at the assembly desk.
The clerk will so note. Colleagues, going back now to the daily file, let's go to file item 33, AB 487. The clerk will read.
Assembly Bill 487 by Assemblymember Gonzalez and others, an act relating to parole.
Ms. Gonzalez, you're recognized.
Thank you, Mr. Speaker. Members, AB 487 is back for concurrence. The amendments taken in the Senate are clarifying and technical in nature. The bill has received broad bipartisan support, and I respectfully ask for your aye vote.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tie the votes. Ayes 65, noes 0. The Senate amendments are concurred in. Going now to file item 34, AB 489. The clerk will read.
Assembly Bill 489 by Assemblymember Gonzalez and others, an act relating to awards.
Ms. Gonzalez, you may open.
Thank you. Members, AB 49 is also back on concurrence. Amendments taken in the Senate are minor and clarifying. The bill has received bipartisan unanimous support, and I respectfully ask for your aye vote.
Seeing and hearing no further debate, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. The clerk will close the roll, tie the votes. Ayes 67, no 0. The Senate amendments are concurred in.